You're about to have your deposition taken. You'll be asked a number of questions under oath by an attorney. Detailed questions about yourself and the case you're involved with. These questions and your answers will be recorded and transcribed by a court reporter. The result will be a written document containing word for word all the questions asked with the answers that you gave. A document that ultimately may be entered as evidence in a court of law. This program will help guide you through this somewhat intimidating legal process. We'll explain why a deposition is taken and show you how to avoid mistakes that witnesses commonly make. Your goal should be to give the best testimony you can, which may ultimately lead to a just resolution of the lawsuit. As you watch, you might have additional questions about the process, what to expect or what to say. Jot these questions down so that you can discuss them later with your attorney, after you've viewed this tape. What's the purpose of the deposition and why is it so important? Well, the primary reason to conduct a deposition is what lawyers call discovery. Discovery is the legal term for the process of gathering all the facts and information that may pertain to a case. It's an attorney's professional responsibility to learn as much as he or she can about any matter handled for clients. A deposition is one of the many procedures used for this purpose. But there are other more subtle reasons for taking depositions. In addition to probing for leads and information that can help or harm their case, a questioning attorney uses the deposition to size you up, evaluate you as a witness to determine your credibility or believability, and to see how well you will present yourself in front of a judge or jury if you eventually are called to testify in court. Furthermore, during this fact-finding, the lawyer is asking you to commit to testimony under oath in the hopes that your answers may contain incorrect or inconsistent statements that can be used later at trial. Finally, it's important to understand that the deposition may well be the only time you ever testify in the case, because most lawsuits never go to trial. Despite the presentations of TV and the movies, more than 90% of all cases settle out of court. So, what you say and how you say it in your deposition are very important and may have an impact on the outcome of the case. If this all sounds a little intimidating, it needn't be. If you just follow the simple guidelines in this video and the instructions of your attorney, you'll do a great job. Your primary responsibility at the deposition is to listen carefully to each question, to make sure you understand the question, and then to answer the question truthfully and accurately. Does this mean you have to know the answer to every single question? Not at all. Will you have to know and remember every fact about the case? Hardly. Should you always tell the truth? Absolutely. Depositions usually take place in a conference room at a law office, hotel, or some other neutral site. At the deposition, there will be at least 3 other people present. First, your own attorney, who's there to make sure that your rights are protected and that you understand everything that takes place. Second, the opposing attorney. This attorney will ask questions in an effort to learn as much as he or she can about the case for the benefit of his or her client. Third, a court reporter. This individual will take down everything that is said on the record. It's also possible that support staff members for one or both attorneys will be present.
Would you please raise your right hand? Do you solemnly swear that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
I do.
With the taking of the oath, the deposition begins. You're now on the record, and anything said will be taken down by the court reporter. However, the court reporter cannot record nodding of the head, gestures, and other nonverbal communications, so you must answer each question verbally. Also, instead of saying uh-huh, say yes, and no instead of uh-uh.
Mrs. Douglas, my name is John Brennan. I'm representing Mr. Howard in this case. If at any time during this deposition I ask a question that you don't understand, please let me know and I'll try to rephrase it. If you answer the question, I'll assume you understand it. Now, state your complete name for the record, please.
Susan Douglas. Susan Mary Douglas.
Are you married, Mrs. Douglas?
Yes, Bob and I have been together for 15 years. 14. It'll be 15 next month.
Do you have any children?
Yes, I have 3.
And what are their ages?
Bobby's 10, and I have 2 daughters. Tracy's 2, and Lynn is 7. No, that's 8 and 2. No, I'm sorry, not yet. One is 7, and the other's almost 2.
Do your best to stay calm. Take your time when answering the question so you don't quickly give the information that you're unsure about, then have to correct yourself. Remember that the result of your testimony is a written document. Pauses will not show up on the transcript. Susan Douglas's case involves a car accident at an intersection. She's suing defendant Reed Howard to compensate for injuries she received when Howard ran a stop sign and collided with a car that crashed into the car she was driving. Even though Mr. Howard was the major cause of the accident, his attorney would like to show that Mrs. Douglas was partially responsible for the accident by either driving too fast or failing to stop once Howard entered the intersection. While the facts of your case will be different, the techniques you'll see demonstrated will be useful in giving effective testimony. Now, let's look at some guidelines for your deposition. In this example, Mrs. Douglas gives the opposing attorney an advantage by volunteering information that goes beyond the scope of the question.
How long were you driving on Capitol Avenue before the accident?
For probably about 6 blocks, because I turned left on Capitol from 3rd. Yes, that's right. The doctor's office is on Capitol on 3rd.
Oh, you were at the doctor's office that morning?
Yes, that's where we were coming from.
When you say we, who were you talking about?
My 2-year-old daughter Tracy and my son.
Why were you at the doctor's office?
I had been up all night with my daughter Tracy. The doctor thought that she probably had strep throat.
In her answers, Mrs. Douglas has gone beyond the scope of the questions, a common error. She's volunteered unrequested information and has given the opposing attorney new leads of inquiry which could damage her case. For example, was she distracted by her sick 2-year-old? Or was she inattentive because of a lack of sleep? That's all it may take for a judge or jury to form an opinion or to draw their own conclusions about the cause of the accident and to possibly weaken her case. Many of us want to be helpful or want to tell our side of the story, but in a deposition, it's unwise to volunteer information of any kind. Here are a couple of easy tips to avoid this common mistake. First, remember to listen carefully to each question asked. Then, limit your answer to that question. When you've provided the information asked for, stop and wait for the next question. Don't let nonverbal cues like raised eyebrows, silence, or a tilted head from the opposing attorney coax you into talking more. One technique to stay focused on the question is to use part of the question in your answer. Let's see how Mrs. Douglas might have answered differently.
How long had you been driving on Capitol Avenue before the accident?
Let's see. For about as long as it takes to go 6 blocks. I was driving on Capitol for about 45 seconds.
Here, Mrs. Douglas thought about her response before she answered. Her answer was brief and to the point. Another simple rule to keep in mind is to be certain that you understand the question. A witness should never try to answer a question unless its meaning is absolutely clear. Questions are sometimes ambiguous and vague because language is not very precise and words have different meanings to different people. Also, lawyers have a reputation of using phrases and terms not typically used by others. Let's see an example.
While you were driving on a preferential road, Mrs. Douglas, you didn't happen to see whether Mr. Howard was going to stop or not, did you?
Yes. I mean, no. No.
Obviously, Mrs. Douglas doesn't know the legal meaning of the word preferential. Let's look at that question.
While you were driving on a preferential road, Mrs. Douglas, you didn't happen to see whether Mr. Howard was going to stop or not, did you?
No matter how she answers this, yes or no, it will be unclear whether she's saying she was looking out or not, or whether she saw that Howard would or would not stop. Don't be afraid to ask what a word or question means. And if you don't understand a question, ask for it to be repeated, clarified, or put in plain language.
What do you mean by preferential road?
A major thoroughfare.
Oh, and can you repeat the question? I don't think I have it clearly.
I agree, Counselor. The question is ambiguous.
Another problem area is guessing at the facts. When a deponent begins to guess or tries to answer when they're really unsure, they're asking for trouble. Just because a question is asked doesn't mean you have to know the answer. This is especially true when discussing detailed issues of time intervals, distances, and speed, such as in this example.
Mrs. Douglas, how far were you from the intersection when you noticed the Howard vehicle?
I was maybe 20 yards away.
And how fast were you going?
I was going the speed limit, 35 miles an hour.
How much time elapsed between the time you saw the Howard vehicle and the impact?
Oh, let's see. That's hard to say.
Well, was it about a minute? Surely you could tell me that.
Well, it was less than that.
Between 30 seconds and a minute?
No, less than that, I think.
Well, was it 10 seconds?
I suppose. I guess that sounds about right.
Mrs. Douglas seemed sure of her distance and speed, but really did not know how long it took her to get to the intersection after seeing Howard's truck. Her mistake was in letting the lawyers suggest an answer by putting words in her mouth and forcing her to guess about the time. This has put her testimony about distance and speed in doubt because the numbers are not consistent. For example, if she was going 35 miles an hour and she really did have 10 seconds to react to Howard's vehicle, she would have had plenty of time to stop. So the judge or jury might conclude she wasn't paying attention. Be sure to review the facts of the case with your attorney so there's no confusion about what happened. And remember, if you don't know the answer to a question or if you can't recall a fact, it's perfectly appropriate to say, I don't know, or I don't recall.
How much time elapsed between the time you first saw the Howard vehicle and the impact?
I'm not sure.
Well, was it about a minute? Surely you could tell me that.
No, I don't know.
Was it between 30 seconds and a minute?
All I can tell you is that I don't know.
In this last example, not only did Mrs. Douglas not guess at an answer, she also did not let the attorney suggest an answer. There are some other times when witnesses are tempted to guess at answers. One is when there's a question or reference made to information contained in written documents. If this happens, you should request a copy of the document in question to refresh your memory.
Mrs. Douglas, isn't it true in the statement you gave to the police at the time of the accident that's in the police report, you stated when asked how you were that you were fine?
Could I see a copy of the report? Thank you. Well, actually, in the report following the statement that you referred to, it says that I was concerned about the condition of my children. Well, that was my primary concern. That was the only reason that I didn't ask for immediate medical assistance.
Here, Mrs. Douglas was able to refresh her memory by requesting to see the police report and show that her statement was taken slightly out of context. Also, watch out that you don't guess about photos, illustrations, or drawings if you're asked to do so. Earlier in the program, we advised you not to volunteer information. But on the other hand, do not try to lie or hide information. If you are evasive, it may also hurt your case. Mrs. Douglas has testified that she continues to suffer from neck pain following the accident.
Mrs. Douglas, since the time of the accident, have you gone on any vacations with your family?
We might have.
Mrs. Douglas, do you or do you not remember taking a vacation with your family last year?
I think we might have.
Well, in the medical report from your own doctor, it says you went skiing. Where did you go?
Vail, Colorado.
For downhill skiing?
Yes, my whole family went.
And did you ski with your family?
I might have.
Mrs. Douglas, do you recall skiing with your family or not?
Yes, I guess I did ski a little.
Did you ski every day?
I'm not sure.
Is it probable that you skied every day?
Yes, I guess so.
Of course, Mrs. Douglas remembers if and when she skied, but she's afraid her complaints of neck pain will not be believed. She'll have more credibility in the long run, however, if she's more forthcoming about her activities.
Mrs. Douglas, since the time of the accident, have you gone on any vacations with your family?
Yes.
Where did you go?
Vail, Colorado.
For downhill skiing?
Yes.
And for how many days?
For about a week.
And did you ski, Mrs. Douglas?
Yes, I sure tried.
In this last situation, Mrs. Douglas was quite forthright when answering these questions. By doing so, she allows her attorney to later argue that even while trying to participate in her family's favorite activity, skiing, she still experienced a lot of pain. So remember, don't offer more information than the question requires. But on the other hand, don't be evasive. A skillful attorney will generally get the information he or she wants and may discredit you in the process. When testifying, resist the urge to get angry, cute, or sarcastic. A witness in Mrs. Douglas' position could easily become angry at being asked so many questions about her own driving when she feels that Mr. Howard is to blame. The danger is that a deponent will begin to advocate or promote his or her case by arguing.
Did you happen to have the radio on that day, Mrs. Douglas?
I might have.
Do you remember if you were listening to any music?
It's possible.
Do you turn your music up fairly loud?
Well, sometimes.
After the time you saw the Howard truck and before the time of impact, did you turn your steering wheel to the left or the right?
How can you ask me something like that? Why didn't you ask him why he didn't stop? There wasn't enough time to do anything.
Didn't you even apply the brakes before the impact?
Oh, well, how could I? Everything happened so fast. Listen up, I had the right of way. He ran the stop sign and hit me. Gosh, I never speed. I always look out where I'm going and yield to others. What do you expect me to say? That I wasn't paying attention and that I ran right into them?
Mrs. Douglas' anger and advocacy may do her case more harm than good. Using phrases like, "I never speed," and "I always look," might make her testimony a little less believable. Stay cool, even when you feel you've already answered a question or if the question is inappropriate. If questions are repetitive or inappropriate, your attorney will step in with an objection. To demonstrate the importance of being clear about the facts during a deposition, here's an example of how the deposition can be used at trial. After her attorney is finished asking questions, Mr. Howard's attorney will have an opportunity to cross-examine Mrs. Douglas.
No more questions, Your Honor.
Do you have cross-examination?
Yes, Your Honor. Mrs. Douglas, your testimony a minute ago was that you were going about 25 miles per hour as you approached the intersection, correct?
Yes.
Mrs. Douglas, do you recall about a year ago coming into my office with your attorney to give a deposition in this case?
Yes, I do recall that.
Your Honor, may I approach the witness with a copy of that deposition?
Yes, you may.
Mrs. Douglas, at that time I asked you some questions that you answered under oath. Is that correct?
Yes.
Would you look at page 17 of your deposition? I would like you to read lines 5 through 10 silently as I read them aloud, and then I'll ask if you gave those answers to the questions. Question. Now, Mrs. Douglas, how far were you from the intersection at the time you first noticed the Howard truck? Answer. I was maybe 20 yards away. Question. How fast were you going at that time? Answer. I was going about 35 miles per hour. Mrs. Douglas, did you give those answers to those questions?
Yes, I did, but see, I really
That'll
didn't
be
know
all,
quite...
Mrs. Douglas.
On the witness stand, Mrs. Douglas' testimony regarding her speed differs from her deposition, perhaps casting some doubt on her story. You can see how important it is to be clear and consistent about every fact you testify to during your deposition. So far, we've discussed guidelines concerning the volunteering of information, understanding questions, guessing at facts, being evasive, staying in control, and being consistent with your facts. Now, let's consider another case to see how the guidelines we've discussed might apply to a different fact situation. A contractor, James Camus, is suing a Mrs. Bernice Hill for money that he claims she owes him for remodeling her house. Mrs. Hill admits that Mr. Camus remodeled her house, but argues that he used the wrong color when painting the house. Mrs. Hill's attorney is deposing the contractor. Mr. Camus is unhappy at having to spend his entire morning answering questions. Perhaps he figures he'll get done faster and get back to work if he tells the opposing attorney everything he thinks she needs to know. See if you can identify the problems that Mr. Camus is creating for himself.
Mr. Camus, did you and Mrs. Hill decide on a color for the house?
She told me she wanted a light gray. So I mixed up some samples, I put the colors on some pieces of wood, and I showed them to her. She picked out the color she liked. In fact, I've got the sample out in the back of the truck.
Good. I'll come back to that. Now, when was the first time that Mrs. Hill expressed dissatisfaction to you about the color you were painting her house?
Well, I was already a week into the job when Mrs. Hill got back from a weekend trip. I was just about through when she tells me the color is too dark. I was shocked. I mean, she had spoken to my wife just a few days earlier on the phone when she was trying to get a hold of me. She didn't say anything to her about it.
In answer to both questions, Mr. Camus volunteered information that went beyond the scope of the question, telling the opposing attorney more than she asked for. Doing so may have weakened his claim. Using the same fact situation, let's look at another guideline to keep in mind. If your attorney makes an objection, it's not time out for you. On the contrary, it's time to pay close attention to the objection made by your attorney.
Mr. Camus, when did you substantially finish the project?
Well, it was about...
I object. The question is vague and confusing.
I can answer
No,
that.
wait, Jim. I want an objection on the record.
All right, counsel, what is it about the question that you find vague and confusing?
Well, the term substantially could be misleading. Do you mean done completely, or done with the painting and cleanup, or what about Mr. Camus's subcontractors?
Okay, I rephrase the question. Mr. Camus, at what point did you or your employees finish applying paint to Mrs. Hill's house?
Well, we finished the painting part of the job on April 18th.
Mr. Camus learned by listening to his attorney that it was important to distinguish the painting from the cleanup in his testimony. By listening closely to the questions, making sure the question is fully asked, and carefully considering your answer, you allow your lawyer enough time to enter an objection on the record. After most objections are properly on the record, you will usually be required to give an answer, unless, that is, you are instructed not to answer by your attorney. Lawyers occasionally may ask to go off the record or enter into heated legal disputes with each other. These two are times to pay close attention and not let your guard down. There are a few other subjects you may want to discuss with your attorney. Ask him or her about the opposing attorney's personality and style. Lawyers use a variety of techniques to gather the information they need. If an attorney is friendly and nice, it may be because he or she thinks it will help the client's case. Be polite, but don't get chummy. Stay alert for every question. At the other extreme, an opposing attorney may try to anger you with sarcasm or intimidation. Try to stay calm and stick to the facts. Your own attorney can and will protect you. The opposing attorney may be aggressive, rapidly firing questions at you, developing a fast pace. If that happens, just go at your own pace. Pause before answering questions and think before you answer. What if you should want or need a break during the deposition? Just ask. You may have one. Also, wear clean, neat clothing. Dress as you might for a business meeting. Now let's review the information we've presented. When giving your testimony, focus on understanding the questions and stating the facts as you know them. As you answer, stay within the limits of the question and don't volunteer information. Don't be evasive. Don't guess at facts. If you don't know the answer to a question, say so. If a question is misleading or confusing, ask for clarification. Don't advocate your case or argue with the opposing attorney. Be consistent in your facts and pay close attention to any objections made by your attorney. Finally, be sure to go over your case with your attorney to discuss any special instructions he or she might have for you. Follow the guidelines we've discussed in this program and you'll do just fine.